Item number 1.
You ready to proceed?
Yes, in terms of your Lordship's order, I have given the compilation of the dates.
All right.
It is only on the dates, we'll not go on
All
married.
right. Pass over at the first call, we are coming back.
Yes.
Number 2.
Lordship, I'm praying, Lordship, if this matter can be taken up on Monday, Lordship, Learned Senior Mr. Goswami is leading, Lordship, in this matter. Lordship,
Yes, Mr.
subject to your Lordship's convenience, Lordship.
All right, on the prayer of learned counsel for the petitioner, this public interest litigation is adjourned for the day.
Number 3.
Hello, Lordship. My Lord, this is a public interest litigation, my Lord.
Yes. For the first time?
My Lord, first time.
Yes, what is the subject matter?
My Lord, the petitioner here, my Lord, it's a society. He is raising two pertinent issues, my Lord. One pertains to issuance of scheduled tribe certificate to children born of a Khasi parents, but they are not following the matrilineal system, they are following the patrilineal system. And in some cases, children are born of a parents wherein one of the parent is a Khasi, the other one is a non-Khasi. They are facing discrimination in getting the scheduled tribe certificates, my Lord. That is one issue, my Lord. And the other issue is, my Lord, as regard to the
Matriarchal and patriarchal, what is the problem? Only in place of the father, the mother's name will be there.
right, my Lord, surname is used. Only on the basis of that, my Lord, there is a discrimination that is done by the state. They have issued an order also, my Lord. Initially, my Lord, there was an order that is at page number 128. This underlined portion, my Lord, there was a clarification which was earlier given, which was in favor of the all the people, my Lord. Here it says, my Lord, it may be stated that the Lineage Act 1997 does not prohibit the issuance of ST certificate to the applicant adopting surname of either from the father or mother, and the practice of adopting husband's surname by non-Khasi wife was also allowed. So this was the procedure which was told to be adopted for issuance of ST certificate. But surprisingly, my Lord, the next page, my Lord, in the year 2024, after many years, my Lord, that earlier letter, my Lord, it was withdrawn. Page number 129. In inviting a reference to the subject quoted above, and as per the minutes of the meeting held on so and so under the chairmanship of Honorable Minister, Social Welfare, the department do hereby withdraw, revoke the letter number so and so dated 21/7/2020 with immediate effect. So this has created problem, my Lord, for all these children now to get admission without the ST certificates in school and colleges, my Lord. So my humble prayer, my Lord, this may be for the time being stayed till the time the matter is disposed.
It is 24.
2024 order, my Lord.
Yes. Where is the Lineage Act 1997?
That act is, my Lord, at page number 59, my Lord. The relevant section is section 3, my lord, page number 61.
Which section?
Section 3, my lord, page number 61.
Yes. Who is a Khasi?
Yes, who is a Khasi, my lord. This is creating problem, and moreover, the act makes a provision, my lord, that they are to obtain Khasi tribe certificate from the district council, and district council also has the right to take away the Khasi status of a person. Now, my lord, as far as scheduled tribe status is concerned, my lord, this is a gift of the constitutions in terms of the Constitution Scheduled Tribe Order 1950, my lord. Now, what is given by the presidential order, it cannot be taken away by making law by the district council, my lord. This is against their legislative competence as well.
This letter of 2020 was regarding
This was a clarification.
use of surname.
Surname, my
That
lord.
has been withdrawn.
Now, in earlier, my lord, the clarification in the year 2020, it was given that even if they are taking the surname of the father, there is no bar that you can issue the ST certificate. You can issue the certificates. But in the year 2024, very recently, my lord, what has happened? They have withdrawn that order. This is why, my lord, now authorities, my lord, they are reluctant to issue the scheduled tribe certificate because of that withdrawal of that earlier letter, my lord.
Where do you need this certificate?
From the Deputy Commissioner's office.
No, where do you need it?
My lord, this is required for the purpose of taking admissions in school and colleges, my lord.
Section 5, you will get the certificate.
Section 5. Section 5, my lord, yes, grant of Khasi tribe certificate, it says. And another thing, my lord, the act makes it a provision that in case if a Khasi male, he marries a non-Khasi woman, my lord, in that case, they are to perform the Tangzait ritual. Now, this Tangzait is, Tang means, in another word, we can say consecrate. And Zait means surname, my lord. It's like consecration of a title. Now, here, this is a rituals which is performed by the indigenous faith of belonging to Khasi faith, my lord. Now, for people who are belonging to Christian faith, my lord, it is not possible for them to do these rituals, my lord. And therefore, in terms of Article 25 Clause 2 also, there is a bar, my lord, that state cannot make law regulating the religious practices. So, even in that way, my lord, there is a violation.
This is a special provision in the Constitution covering religion also, that the general 25 will not apply fully. Why don't you understand this? There is no problem here There is provision for issuance of certificate. Or only the surname you have the option, father's name or mother's name.
Now, if suppose a person is children are taking the father's name, they are being denied the scheduled tribe certificate. That is the grievance, my lord.
Where have you stated it?
Yeah, I have stated in my paragraph, my lord, because of. Paragraph 2 also, my lord, I have stated that only relevant person, my lord, I am reading. Petitioner is filing this public interest litigation raising the issue of derecognition of children born out of Khasi parents as non-Khasi, merely for reason that the parents are not observing the matrilineal system and their children took the surname of the father, and as such deprives such children of the scheduled tribe status being a Khasi. The petitioner have further raised concern with regard to the matter of inheritance, succession and lineage act. The other issue, my lord, which I have raised in this petition, my lord, even till today, my lord, the male member in the Khasi society, my lord, they do not have the right to inherit the parental or ancestral property, my lord, till today.
That you have to approach the council. It has the power to legislate.
There is no legislation in that regard giving rights to the male, my lord. This is clearly violation of their rights.
Anyway, who are to be noticed? This has to be heard
my
of.
lord, district council notice has to go to the district council.
This is only the Khasi lineage act you have placed.
Yes, so my lord,
One district council only.
only one district council, my lord.
The others
Others, no, my lord, they have not legislated.
you are representing?
My lord, I'll be representing the state respondents, my lord. All the respondents except number 3, my lord. 3 is district council. Khasi is autonomous district council, my lord.
You are representing?
My lord, I'm not representing number 3. The remainings I'm representing.
Notice has to go, my lord, for respondent number 3.
Let notice go first. Huh? This public interest litigation is of some importance. First, it is initiated by Singkong Rimpei Thaimai, a registered society under the Meghalaya Societies Registration Act, Roman 12 of 1983. Through its General Secretary, Mr. Armour, ARMOUR, Lindo. The society has its registered office at Madan Laban, East Khasi Hills District, Shillong. Paragraph, this writ application no, just write it out. The structure of the society comprised of the Khasi tribe is by tradition matriarchal. A is by Articles 244 within bracket 2 and 275 bracket 1 of the Constitution of India, the sixth schedule has been grafted into the Constitution. The sixth schedule has been grafted thereto, giving special status and rights to the scheduled tribes in specified areas, which includes Meghalaya. Full stop. Khasis are one of the major tribes in this region. This schedule, inter alia, provides for district and regional councils with power to legislate. Legislate in subject matters involving these tribes. And the core issue which is highlighted today by learned counsel for the petitioner arises out of issuance of scheduled tribe certificates by the Social Welfare Department on 21st July 2020.
Yeah.
It notified the Deputy Commissioner, East Khasi Hills District, that the Lineage Act 1997 did not prohibit the issuance of scheduled tribe certificates to those applicants who were adopting quotation surnames of either from the father or mother, and the practice of adopting husband surnames by non-Khasi wife. Unquote. See page 128. Huh? This decision was revoked on 21st May 2024 by letter. No, as far as the first thing is concerned, please read out first. 21st July.
July 2024, the Commissioner in the District has been Act 1997 did not prohibit.
No. Deputy Commissioner, East Khasi Hills District, by endorsing the advice received from District Council Affairs Department, that then whatever I've said. Learned counsel for the petitioner submits that as a result of this communication, issuance of scheduled caste certificates have been stopped by the government. We have seen the Khasi Hills, paragraph, we have seen the Khasi Hills Autonomous District, bracket, Khasi Social Custom of Lineage, bracket close, Act 1997. It applies to all Khasis in Khasi Hills Autonomous District. In section 2 within bracket H, quotation Khasi is defined. In section 3, if either of the parents of a child is Khasi, no, where both the parents are Khasis or either of the parents is a Khasi, the offspring remains a Khasi. No, the offspring is also a Khasi. But each type of progeny is differently described in the section. Section 5 provides for registration and grant of Khasi type certificate. Paragraph. We would like to understand how the option of a person to adopt the surname of one's father or mother would change the obligation of the authority under the said act to register a Khasi and grant him or her the quotation tribe certificate. Paragraph. This public interest litigation is formally admitted. We direct the petitioner to serve copies of the petition on all respondents except the state, which is represented by learned counsel today. On the returnable date, the District Council Affairs Department shall file a report in this court pertaining to issuance of scheduled caste certificates, scheduled tribe certificates, to persons opting for the surname of their father or mother and to women who choose to adopt the surname of their husband. List is public interest litigation once again on July 23rd.
In the meantime, my lord, this order dated 21st May 2024. This may kindly be.
No.
kept-
You are coming after 1.5 years.
Well.
You just wait for 1 month.
Obliged. Obliged.
Second call, item number 1.
In terms of your lordship's directions, we have filed a list of dates.
Yes.
But he would like to address your lordship first, I think. My
Keep the pens here.
your lordship's earlier direction, your lordship has asked us to give the list of dates to show that it is time bound. That we have filed it in the form of a supplementary paper book. Your lordship will find that list of dates at page 52, last page of the supplementary paper book. The last page, my lord, 52. Now, if your lordship looks into that list of dates, my lord, your lordship will find the first date is 28/9/2010. This was the day on which the interim order was passed to not give effect to the impugned communication dated 21/9/2010. Then this interim order was ultimately dismissed and vacated on 19/10/2010. Then, my lord, the
Lordship, I beg to
Yes.
submit here.
Let him submit, my lord.
How we were proceeding, gentlemen.
No,
I
no,
have
no.
not
My
asked.
lord has asked me to furnish the dates I have given.
You
And that's why I have
maintain
told him.
that.
He wants to address your lordship. Let him have the again.
I'm the
Yeah,
appellant
last
who
time,
was
last time he
started-
has addressed it, your lordship. We reached a point where these dates was there. So let him address. Then I will point
Let
out.
me address the court. I have the right to start with first.
No, no, no. It's already part of it.
No, practically didn't start. Now
No,
today it started.
we are maintaining a cordial atmosphere in the court. Why are you?
No, no, I am
leaving
not
your-
saying about-
You start your appeal. Don't. We are having a very peaceful atmosphere here. Don't.
No, no, Lordship,
do away
I'm
with
not
that.
telling. I'm just requesting my friend.
That's all.
Let me start formally.
Your tone was very.
Your
attacking.
Lordship will be confused that who is the plaintiff. I appellant here.
Yeah, please proceed.
So may I be allowed to proceed, Lordship?
Yes.
Yes, Lordship. Lordship, before I proceed, we have in this matter, as per direction of the Honorable Court, filed a paper book, Lordship, giving the entire appeal with its annexure, etc. And thereafter, on the later stage, Lordship was pleased to direct when my learned senior friend was raised a question that a copy of the plaint before the trial court was not placed. So that has been also been placed, Your Lordship. Now, if I am allowed further to proceed, Lordship, I have made a synopsis of my submission before this Honorable Court. And if this true synopsis is...
Yes. Status quo until 2028. We are we don't say. Termination contract, it was the termination of contract is 18/1/2018. Early 18/1. Because status quo data will lose it. It says to us. Minus. It will come status quo order to follow. Status quo order 20 into 8 is should to find. 1 8 to come again. Suppose the date of filing for the date also, we should put filing by date of filing is 2011. Starting point to the project, you don't want to give this thing upload, but have you identified what do you
Mr. Chaudhary,
Yes, Lordship.
kindly come to page 5.
Yes, Lordship.
For 3 years, from 8/3/2018.
Yes, Lordship.
How are you getting 3 years?
I have given Lordship.
Now, if you come to page 3, paragraph 6.
Yes, Lordship. Can I read, Lordship?
No.
Okay.
Termination
That there.
18/1/2011.
Yes, Lordship.
All right.
Yes.
Now, please turn the page over. Page 4.
Yes.
First new paragraph. C4. Fifth line.
Page 4, paragraph 2nd, Lordship.
Page 4.
Yes.
No, the first new paragraph, not paragraph 7, before paragraph 7. Now the failed contractor.
Yes.
Third
Now
line.
should I read, Lordship?
No. 22/8/2001 is the order of injunction. Status quo.
Yes, Lordship.
All right.
Yes, Lordship.
So from when are you calculating the accrual of cause of action? From the date of termination or from when?
Till from this date, Lordship, I have given in page number 7 here, but the table I have given, Lordship.
No, from
So
when?
table, the cause of action,
Action arose on 18/1/2011 or subsequent date?
18/1/2011.
Cause of action.
Yes, Lordship.
Now from 18/1/2011
Again, 3 years starts, Lordship.
to 22/8/2011, you have to calculate. That is the status quo order.
Yes, Lordship.
Yes. 7 months. So 7 months have already run. Then intercepted by status quo order. Status quo order vacated on 2018. Now the balance of this period is excluded. Section
Yes.
18, 19, whatever of the Limitation
Yes,
Act.
Lordship. Yes.
This period. Now the balance, 3 years minus 7 months, will run from 2018 vacation of the interim order. Now that ended much before COVID. Now if that ended much before COVID, no protective orders of COVID will save you.
Lordship, if I am allowed just to...
Yes, please. So if it was alive on 15 March, I think from 15 March it has been made operative by the Supreme Court, then again you get a,
COVID period, Lordship.
yes, there's the
COVID
exclusion.
period. There is the, Lordship, that is the mistake the Honorable Learned Trial Court made, Lordship.
Yes.
If your Lordship's attention, I drew to page number 220, the last page of having the order, impugned order, last page of this paper book, 220. What happened, Lordship, here, before coming that, we are to go to the Honorable Supreme Court's order, Lordship. Supreme Court's given a blanket exemption period from 15th of February 2020 to up to 20th of February 2022. Total 700 and some days.
15th February or 15th March?
15 March, Lordship. To up to 28th February 2022.
Yes.
So there I have mentioned, Lordship, if your Lordships, I drew attention, Lordships, to para number 7 of my synopsis, and I may kindly be allowed to read it, that the status quo order was vacated as above stated after 6 years, 6 months and 8 days. The cause of action to realize the final amount that could not be calculated at the end of the 2 years contextual period of 13/6/2012 had shifted from 17/1 to 1/2024 with 3 years fresh limitation period having been marched in the total time period of 6 years, 6 months, 8 days consumed due to different reasons as to vacate the status quo order dated 29/8/2011 by order dated 7/3/2018 according to law as the period as provided under section 12 of 14 of the Limitation Act 1963 and shifted from 8/3/2018 afresh. Now here, of course, Lordship, I have Lordship's attention drawn to one Supreme Court's ruling that I will present before your Lordship. Next, the period of limitation for 3 years from 8/3/2018 to be ended by 7/3/2021 was again intercepted by due to COVID-19 pandemic declared officially by the state government from the middle of March 2020 and continued till the end of February 2022, when during this 2 years period, national and international civic life was in stake, and to overcome the problem of limitation throughout the country in the matter, the Honorable Supreme Court suo motu excluded the period from 15/3/2020 to 28/2/2022 from the purview of limitation with the further period of 90 days if the limitation period in any case had expired during the period 15/3/2022 to 28/2/2022, notwithstanding actual balance of limitation remaining, all persons shall have a limitation period of 90 days with effect from 1/3/2022. Lordship, in the case in hand, the limitation for 3 years from 18/3/2018 had expired on 7/3/2021, leaving no balance as on 10/3/2021. As directed by the Honorable Supreme Court, so the present case falls under column 3 of the order as
Mr.
reflected
Chaudhary,
in Annexure 20.
Here,
Yes, Lordship.
kindly consider your page 5.
Page 5, Lordship, of
Yes.
my synopsis, Lordship.
Yes. 5th line.
Page 5,
5th line.
5th line.
Next, the period of limitation for 3 years from 8/3/18 till 7/3/21.
Was again intercepted due to COVID pandemic, Lordship.
How was it intercepted?
Pardon, Lordship? It is
From by 15th March 2020, it is dead.
No, what happened, Lordship?
7/3
From 18/3 to 8/3/2022 to be ended on this is the 3 years period, Lordship.
No.
During this period, COVID has entered, Lordship.
No, when was the order vacated? Injunction?
Order vacated on 7/3/2018. Here, what happened, Lordship, I beg to submit that this is a corporation and so many calculations were to be made, and the office of the corporation was shifted to its new original place, newly acquired building they have constructed. So all this has made little delay, Lordship. And by that time, COVID entered, Lordship. So since from 8/3/2018
No, as
to
we
next 3 years,
observe-
a person can or a litigant can come within 3 years and file it,
It's
Lordship.
all right.
That is my submission.
But when the status quo order was passed,
yes,
the time had already run for 7 months.
Yes.
Lordship.
Status quo order.
Status
as
quo,
I told you,
status quo by
Your-
trial court or by the High Court, Lordship.
no, your cause of action, as you said, 18/1/2011,
Yes, Lordship.
paragraph 6,
Yes.
termination. All right.
Yes.
22/8/2011 is the status quo order. Let us take it as an order of injunction.
22.
Under 8/2011.
28/2011. So let me
So
explain,
it is
Lordship, here.
7 months.
Yes, Lordship. Let me explain, Lordship, here. That now the failed contractor then filed a civil suit on 8/1/2011 before the learned assistant to the Deputy Commissioner Shillong by such and such, for an ad interim injunction, and by which obtained an order on 22/2/2011, and by order dated 29/8/2011 to maintain status quo till the suit is finally decided. No demand letter could be issued for the subsequent loss because.
So
of this-
18/1, let us be short now. To
Yes.
22/8, 7 months have gone.
7 months period, which period, Lordship?
Cause of action has started from the date of termination,
Yes, from 18.
18 to 18/1 January. That is the start date.
Yes.
Accrual of cause of action
Yes, Lordship.
and start of the period of limitation.
Started from 18/1/2000. A 3 years limitation will add.
7 months. All right?
Yes,
So
sir.
you are left with 2 years, 9 months. All right?
Yes, Lordship.
Now this continues. There is stoppage of period. It stops. 22/8/2011. Again it starts running, as you say, 8/3/18. So you have how much? 2 years, 3 months, or what did I say?
Your Lordship is right. 800.
5 months. 2 years, 5 months. So it is 9/3.
No, Lordship, if I am allowed to submit, Lordship, I am going in a broader sense, the broader perspective, that my cause of action arose from 18/1/2011, and I am getting a 3 years period till it is 17/1/2014. So, the limitation period of 3 years was arrested by 29/8/2011, Lordship.
You might be right. 8/3/2018 to 8/3/2020 is 2 years.
No, I'm not going in that way backup manner, Lordship. I'm going
Plus-
when my
No,
cause
this
of
is-
action arose of
this is in
18/1,
your favor.
I'm getting a fresh of 3 years, Lordship. That is my
How?
submission. 3 years period I'm getting,
How?
Lordship.
You will only get 3 years if there is acknowledgement of liability. If the injunction stops it, you will not get. But still, from 8/3/2018, if you get 2 years and 5 months, you are into 2020 March, maybe August.
No, thereafter they have filed a civil suit, Lordship. They filed civil suit. Kindly allow me to explain, Lordship, here. Paragraph number 8, probably I have gone. Page number 7, I am just explained to you, Lordship, how we have calculated. Cause of action arose for the first instance when the contract was terminated subject to contractual obligation, Lordship. That is from 18/1/2011. This 3 years period would have ended by 17/1/2014. Now, what happened? This period, Lordship, 17/1/2000, I have explained here in the body of my submission. Paragraph number 7, Lordship, here, that the status quo order, page 4, paragraph 7, the status quo order was vacated as above stated after long 6 years, 6 months, 8 days. The cause of action, so to realize the final amount that could be calculated at the end of 2 years contractual period by 13/6/2012 had shifted from 17/1/2014 with 3 years fresh limitation period having been merged in the total time period of 6 years, 6 months, 8 days consumed due to different reasons to vacate the status quo order. By 29/8 order dated 29/8/2011, Hyde order dated 7/3/2018. 7/3/2018. So this period we got involved in the case. Next period for limitation for 3 years from 8/3/2018. Now I'm coming, Lordship. After it is vacated 7/3/2018, the next period of 3 years starts from 8/3/2018 afresh.
Why afresh?
Afresh means because I'm obstructed, Lordship, by this 6 years period was I'm obstructed.
That is
so
excluded.
it is shifted afresh with the action of the parties. See, the limitation is shifts one point to another point, Lordship.
Yes.
So, the next period of limitation of 3 years of 18/3/2018 ended by 7/3/2021, Lordship. Next period is coming. Was again intercepted by COVID, Lordship. When we wanted to proceed with the matter and everything was more or less made ready, the national life was cut off from this pandemic. So, what happened, Lordship? When the pandemic was over, then we started the process, and therefore we made a submission on paragraph 8 that, Lordship, in the case in hand, the limitation period of 3 years from 8/3/2018 had exhausted on 7/3/2021. When this COVID period, within the COVID period, it is exhausted. COVID period is exhausted. As directed by the Honorable Supreme Court, the present case falls under column 3 of the order as reflected in Annexure 20, relevant pages 140. Therefore, the Lordships, the Lordship Honorable Supreme Court had granted a total period of 716 days from 15/3/2020 to 28/2/2022 plus 90 days beyond 1/3/2022 equal to 8 years, 806 days or 2 years, 2 months, 16 days to be excluded from the delay occurred, if any, Lordship. Now, Lordship, the commercial suit number 11 of 2023 could be filed on 21/3/2023, whereas the suit was required to be filed on or before 7/3/2021, and therefore the delay of 2 years, 14 days.
No. When was it filed?
Pardon?
Suit when filed?
21/3/2023.
I filed it 21st March 2023, Lordship. And that was filed because we had to complete the Section 12A Commercial Courts Act 2015, where we lost 154 days. Now, if entire thing will be clear, Lordship, if your Lordships just makes a perusal of the order sheet, imperial sheet at page number 220. Actually, the mistake has occurred in the hand of the learned trial court.
When was the bar lifted by the Supreme Court?
Just
By
2022. 28
February 2022. Then we resorted to that Section 12 A provision for mediation, which is a compulsory, Lordship. And thereby we lost 154 days. Now, let me just apprise your Lordship that according to the Honorable Supreme Court's order, the assessment of limitation, balance period, etc. to be done on 3/10/2021. 3/10. But the learned trial court below made a mistake assessing the balance period of limitation on 15/3/2020. finding out that at that time, your humble appellant had 4 months, 21 days, such and such. That is the mistake occurred, Lordship. Whereas on 3/10/2021, your humble appellant had already exhausted. No period was in their hand. And therefore, as per the Honorable Supreme Court's order, the appellant is entitled to get another 90 days from 1/3/2022. Therefore, Your Lordship, I have given a calculation table. If it is just kindly mark it, that cause of that limitation period of 3 years under column 3, limitation period of 3 years was arrested from 29/8/2011 and merged in the period of time consumed as per provision of Section 14 of the Limitation Act. I have here referred Honorable Supreme Court's order ruling AIR 1994 Supreme Court 2329 for the status quo, page number 8, Lordship. For the status quo order of Civil Code dated 29/8/2011, which automatically got vacated as the injunction petition was rejected by order dated 7/3/2018 after 6 years, 6 months, 8 days. Limitation then again shifted to 8/3/2018. Next point, we have found out next 3 years limitation period beginning from 8/3/2018 and ended to 7/3/2021. 7/3/2021, next 3 years is going to totally exhausted in the midst of the COVID period exemption, leaving no remaining balance of limitation. Number 5, that the suit could be filed observing the period process of Section 12A of the Commercial Courts Act 2015 on 21/3/2023 after a lapse of 2 years, 14 days. Now, I have given here the minus 2 years, 14 days. Then the exclusion granted by the Honorable Supreme Court by order dated 10/1/2022, annexure 22 at page 137. The relevant page is 139. As stated that plus 2 years, 2 months, 16 days. Now, when we minus it, when we get a exemption of 2 years, 2 months, 16 days, and our delay is 2 years, 14 days, we get as if that case, this money suit was filed ahead of 2 months, 2 days, Lordship. That is the calculation we made. Now, here again what happened, the learned trial court has not given us the benefit of section which were entitled the time lost in the before the Meghalaya State Legal Services Authority for conciliation under Section 12A, stating that we had gone to their level of that authority after the limitation period is over.
We'll hear you tomorrow again.
My lord, I'll just take 5 minutes at the most, my lord. My learned friend has it is only about the dates. Your lordship will see. Your lordship is right. Your lordship has said that they.
No, you are not here tomorrow.
Yes, my lord. I'm not here.
No. Monday,
my lord, because the vacation in Guwahati has started, my lord, I'll be going to Delhi I will be away till. But let my learned friend compare. I'll just point out 2 dates. Your lordship.
all right. If you are on vacation, we will permit you to complete your submissions online. If it is possible from Delhi.
My lord, I can do it from, or if it is not inconvenient, I can come again on 30th of July.
30th of July.
30.
That is a long time. We will forget everything.
No, my lord, your lordship will not forget. My lord, I'll just for 2 minutes, I know your lordship will answer. 2 minutes, I'll just take off your lordship's time. My lord, your lordship has rightly said that the starting point of limitation starts on 18/1/2011. After that, there is a 7 months, there is a period which they have gone. Then after that status quo order was vacated, the limitation period will start from the status quo period plus minus this 7 months. Then this filing of the suit, if you count the 7 months, then 2 years, 5 months, then that date falls within the COVID period. Now, as per the Honorable Supreme Court direction, if it falls within the COVID period, then if it is less than 90 days, you will get the entire COVID period as well as the 90 days. But if it is more than 90 days, then you will get, in this case, the limitation period expired beyond 90 days, around 4 months and 21 days. So you will get the entire limitation period as well as the 4 months, 20 days. Now, the new date which was, they had to file it, was again shifted to, my lord, 22/7/2022. When it shifted to 22/7/2022, there was post-COVID, the limitation period ended on 22/7/2022. They again waited there for another 60 days to file the pre-mediation litigation, that application. Then 25 days after delayed, after the COVID period, including the 4 months, 11 days were expired. Then they went to mediation. The mediation again resulted in non-starter on 21/2023. Then again, after 60 days of the non-starter petition, they filed this civil suit. So in total, as the learned court below has concluded, that it is 4 months, if you include, then if you include the period from 22/7/2022 till 16/8/2022, when they initiated the pre-mediation, there you were delayed by 60 days. Then again, when the non-starter petition was given, after that also there is a delay of 25, total 85 days. And in case of, my lord, in a money suit, there is no question of section 5, it's always section 3. 1 day delay is also fatal. I am here to only to, this is the date which I was trying to point out at 52. This is the simple arithmetic we have to do, my lord.
Lordship, my friend, senior friend is misleading. Because we are only concerned that at what point of time, any time in hand, the learned trial court calculated.
All right, Mr. Chaudhary, how much more time you will take to finish your submissions?
This matter today, Lordship.
No, today it is over, next day. How much more time you will take?
Hardly, because Lordship has already entered into the matter. 1 hour time maximum I will take.
Yes, you, please. You can agree on a date.
I can come on 25th, my lord. 25th of July.
Not even online before that.
Online, my lord, I'll be in Delhi. I don't have the equipments in Delhi because I'll be going for a checkup also in Delhi for master health checkup. Online equipments I don't have in Delhi, my lord. That will be a problem for me because the High Court vacations ends in.
All right. We have substantially heard this appeal. Full stop. As the summer vacation of the Guwahati High Court is intervening, the next date of hearing by consent of learned counsel for the parties is fixed on.
Your lordship will fix it on 30th of July only. I'll just take 5 minutes, my lord. I'll not waste the judicial time of this honorable court.
30th July.
Yes,
30th July.
Yes.
Yes.
we are obliged, your lordship.
Thank you.